In this module, we will begin exploring the legal and medical aspects of providing emergency care as a paramedic, starting with consent and refusal of care. Once completed with this module, you should be able to define consent to care, define types of consent, and describe concepts related to the refusal of care or transportation. This module addresses legalities related to patient consent. In providing this information, nothing in this presentation should be construed as legal advice. Rather, the information provided is merely a broad overview of this legal subject as denoted within the National Paramedic Educational Standards. Please be aware that every state has different laws that impact EMS agencies and providers, and these laws may change over time by application of legislative action or court decisions. Federal, state, and local laws and other legal provisions not discussed within this presentation may also impact EMS agencies and providers. Additionally, information that was current or applicable at the time this presentation was produced may not be at the time you are watching this presentation, and new laws may have been added as well. Lastly, the legal topics and doctrines discussed within these presentations are not the totality of all laws that apply to EMS agencies and providers. There are numerous other laws and provisions that impact diverse aspects of providing EMS. If you or any other EMS provider has questions related to the laws that apply to him or her within the realm of providing EMS, additional guidance and assistance should be obtained from a licensed attorney within your area who has subject matter expertise in the specific area of law in question. Individuals are afforded great personal autonomy and self-governance rights within our society that allow people to live life as they deem most appropriate for themselves. Within the realm of providing medicine, these personal autonomy rights allow individual patients to choose healthcare options they feel are in their best own interests or consistent with their own values and beliefs. While we will discuss types of patient consent in just a moment, allowing patients to make the best possible choices for their personal health typically requires those patients to be aware of the nature of the particular illness from which they are suffering, various treatment recommendations for addressing the illness, risks associated with both the various treatments for the illness as well as those associated with not pursuing additional care, and other alternatives the individual may have outside of traditional treatment plans. The concept of consent is important for healthcare providers because various types of medical skills and treatments are invasive or require some type of touching. If a patient does not consent to care or treatment, that typically means the law prohibits the healthcare provider from forcing that care or treatment onto the patient. There are a few exceptions which we will discuss in a little bit. Generally speaking, however, forcing care onto a person who does not want it can give rise to civil legal liability and may also be considered a crime. When discussing patient consent, especially within emergency medical services, there are numerous types of consent that are recognized by various laws. The first is expressed consent. Expressed consent is probably the cleanest type of consent in that the patient expressly provides the healthcare provider with permission to provide care. This consent can be either verbal or nonverbal. Verbal consent involves spoken or oral permission to treat by the patient. Nonverbal is obviously when the person does not say anything, but through his or her actions is obviously providing consent for treatment. If a patient has capacity to provide consent and does not actually object to the EMS provider's actions and subsequent assessment and treatment, consent is inferred from the patient's lack of refusal to that assessment or care. While this may sound like implied consent, which we will discuss momentarily, the fine line is that the patient has capacity to consent and, through his or her actions, obviously allows the EMS provider to do whatever he or she needs to do in the patient's best interest. Implied consent comes into play more when a patient lacks capacity, but more on that in just a bit. Also related to express consent is the concept of informed consent. Essentially, informed consent is expressed consent that is provided by the patient once he or she is provided with adequate information from the healthcare provider to make a deliberate and informed decision as to what treatment options, if any, the patient would like to pursue or allow. As discussed in the previous slide, this means the patient is informed of what specific condition is impacting his or her health and well-being at the moment, which often includes details of how the illness works, the body systems involved, the potential signs and symptoms the patient would exhibit or experience, and a potential prognosis given treatment options or a lack of adequate care. Thus, to be fully informed, the patient must also be provided with information related to possible treatments, risks and side effects associated with those various treatments, and the potential benefits of receiving medical care for the ailment. Part of this full disclosure must also include the risks associated with not seeking or obtaining treatment or medical care to address the ailment, possible additional signs, symptoms, and complications that may arise, and what options the patient has if care is not provided and things worsen for the patient. Essentially, the healthcare provider assists the patient in performing his or her research on the topic to be able to make an informed decision. That is informed consent. Given the complicated and dynamic environment in which EMS often operates, it is often not feasible for an EMS provider to obtain express consent, much less informed consent, from a patient. This is where the concept of implied consent comes into play. Essentially, if a person is experiencing a medical, traumatic, or other emergency and needs help, the law assumes that the patient, if he or she had the capacity at the moment to provide express consent, would do so to preserve his or her health. Also referred to as the emergency doctrine, implied consent often applies in cases of patient incapacitation, whether that be physical incapacitation, such as being unconscious, or mental incapacitation, like that after suffering a significant head injury or stroke. If an EMS provider comes across an unconscious person who obviously needs help, the provider need not wait until the person regains consciousness to help. The law assumes, absent prior valid and legal instructions from the patient, that he or she would want help. It is important to keep in mind that implied consent does not give the EMS or healthcare provider carte blanche with the patient to do whatever he or she feels like doing. The care provided must be limited to addressing the particular ailment that is impacting the patient at that time to preserve the patient's life or immediate well-being. While not common, the law also recognizes instances in which patients may be compelled to receive health care even if it is against their personal wishes. This involuntary consent typically involves patients with mental health issues, such as suicidal ideation, or those who are incarcerated or within police custody. Each state has specific laws that describe the circumstances in which involuntary consent may be appropriate or applicable. As constitutional issues, due process in particular, abound whenever a governmental agency, such as a police or other law enforcement agency, begin impeding personal autonomy and individual rights to self-determination and autonomy, these involuntary consent scenarios are typically limited and well-defined. Even if a person is incarcerated, that individual still maintains significant personal autonomy rights related to his or her personal health, and just because a police officer says a patient must be treated or transported does not necessarily mean that police officer's assessment of the situation is correct. Again, because the laws vary significantly from state to state, EMS providers must be familiar with the laws within their own state as they govern involuntary consent. We will talk about Wisconsin's protective custody law in the next slide. Minors, typically defined as a patient under the age of 18 years, can be tricky for EMS providers as far as consent is concerned. In most states, Wisconsin included, minors do not have the same rights to self-determination as adults. Essentially, minors lack the legal capacity to consent to care, which also means they lack the capacity to refuse care or transport as well. Before treating a patient under the age of 18, or whatever the age of majority is within the particular state, EMS providers will need to obtain parental consent. If no parent is available, EMS providers can sometimes rely on the legal doctrine of in loco parentis, whereby an adult with responsibility or authority over the child may give permission to treat in lieu of the child's actual parents. Examples could include the child's grandparents, step-parents, or maybe even the principal or nurse at the child's school. Some states recognize the mature minor doctrine that holds a minor may be able to make healthcare decisions for him or herself if it can be demonstrated that the minor has sufficient intelligence to understand and appreciate the consequences of the proposed medical treatment or procedure. If all else fails, implied consent would apply, whereby the law assumes the parents would want the EMS providers to help the child to the extent necessary to preserve the child's life, health, and well-being. Many EMS texts also make a big deal out of pointing out that some minors may be considered emancipated under the laws of a particular state, which means a child, even if he or she is under the age of 18 or whatever the age of majority is within the particular state, is considered an adult under the eyes of law. Such emancipation can occur when a minor is married, the minor is serving in the armed forces, or there is some other reason for which the minor needs to be considered an adult under the eyes of the law. Again, emancipation is very state-specific, and Wisconsin does not have a formal emancipation process. This can actually create some confusion, such as the case of a 16-year-old female with her own child. The 16-year-old mother can make healthcare decisions for her child, but technically cannot make her own healthcare choices, as her parents still have legal authority to consent for or refuse care for their 16-year-old daughter. Circling back to involuntary consent, many states have laws that allow law enforcement or some other appropriate governmental agency to forcibly detain a person to prevent self-harm, suicide, or harm to others, such as battery or even homicide. Within Wisconsin, State Statute 55 governs emergency detentions of individuals who may reasonably present a threat of harm to themselves or others. The detention period is limited, and only specific individuals may initiate the emergency detention. EMS providers must contact law enforcement for assistance. Beyond involuntary detentions, there are also times when a patient may be violent, and EMS must restrain the patient to prevent further harm to the patient or others, including themselves. An example may be a patient with a head injury who is violent as a result, a psychiatric patient during an interfacility transport, or maybe the elderly patient with Alzheimer's who tries to hit the EMS providers. That restraint must be based upon the reasonable belief that the patient is at risk of harming himself or herself or others, and the restraint must be limited to that which is reasonable to prevent the harm. Regardless of how unruly the patient may be, it is never acceptable to use restraint or use of force as punishment or form of retribution against the patient. Over time, EMS has transitioned from physical restraints to chemical restraint in some circumstances, using medications like ketamine to incapacitate the patient. Needless to say, any EMS restraint or use of force must comply with well-drafted and legally defensible policies, procedures, and protocols. Because each state has different laws that would possibly apply in these circumstances, it is important that those protocols be drafted with the assistance of an attorney in the particular jurisdiction in which the EMS provider is functioning. Ultimately, it is important for EMS providers to understand consent and how it applies to providing emergency care in the field, because a failure to follow laws related to consent can result in potential legal liability for the EMS provider. Abandonment occurs when a provider stops delivering care without the patient's consent to do so, or, looking at it inversely, without the patient's refusal to receive care. False imprisonment is a forced and unwanted confinement of a person. Making a person go to the ambulance or refusing to let a person leave the ambulance can give rise to false imprisonment. Assault and battery are closely related. A battery occurs with an unconsented, harmful, or offensive touching. If you have a patient who refuses an IV and you start one anyway, a battery has occurred. Assault is often defined as an attempted battery, where a person is put in apprehension of a harmful or offensive, unconsented touching. In many cases, these occurrences can constitute not only a civil wrong, which may give the patient the ability to successfully file a lawsuit against the EMS provider, but they can also be a crime. As far as consent is concerned, it actually works both ways, if you will. Not only does the patient have the right to provide consent to treatment, but the patient also has the right to refuse that treatment as well, even if that failure could result in almost certain death. This can be a difficult concept for EMS providers, especially those new to the profession, to grasp, as many cannot understand why someone would not want help for an emergent medical need. Remember that individuals have very strong personal autonomy rights within the United States, which includes the right to self-determination in healthcare decisions. As much as he or she may want to, the EMS provider cannot substitute his or her wishes or values for that of the patient. While it has been mentioned before, it is important to recognize the role of capacity in the ability of someone to consent to or refuse medical care. Capacity is also different from competence. Some people tend to use the two terms interchangeably within this consent discussion, but the two are very different things. EMS providers cannot make a determination as to whether a patient is mentally competent to make decisions for him or herself. That is usually a diagnosis made by a psychiatrist or other adequately trained and credentialed medical professional. What EMS providers can do, however, is make a determination as to whether or not the patient has capacity. First, the patient must be lucid, being alert and oriented. The patient must also be able to reasonably understand the consequences of his or her decision. As a result, when talking about patient refusals, it is important that the EMS crew inform the patient of the risks associated with not seeking further medical care. If the patient is adamant about not being transported by the EMS crew, the EMS providers also have an obligation to tell the patient he or she can still call 911 again if the problems return, worsen, or if the patient changes his or her mind. Where things become challenging is if the patient is deemed to lack capacity. Implied consent helps the EMS providers provide care for a patient who lacks capacity to consent, but it does not provide much help in the event of a patient who lacks capacity yet wants to refuse care. A common scenario could be a 17-year-old patient who was involved in a minor fender bender. In many states, the 17-year-old patient is still a minor who lacks the ability to consent to health care or, inversely, refuse care. If the EMS crew is unable to reach a parent by phone or some other means to verify a no transport, what are they to do? In some jurisdictions, they are required to transport the patient, even if he or she has no injuries and does not want to be transported. The patient's 18th birthday could be the very next day, and that is irrelevant as he or she is still not considered an adult with the ability to make those personal healthcare decisions in the eyes of the law. As with many legal issues discussed within these various modules, having protocols in place ahead of time to address various scenarios like this is of critical importance for EMS agencies and providers. Along somewhat related lines, if a minor child needs care in the opinion of the EMS crew, yet the parents refuse, there is typically nothing the EMS provider can do unless certain death may result. Some parents have religious beliefs that prohibit them from obtaining medical care, and their beliefs extend to their children in most cases. While most states do not allow that parental right to extend to circumstances that would result in certain death to the child, fighting that battle at an emergency scene is routinely a no-win scenario for the EMS crew. Involvement of law enforcement, social services, and other governmental agencies may be required at that point. This presentation is not designed to delve too deeply into possible what-if legal scenarios. Because the laws in every state are different, EMS providers are encouraged to speak with their service directors, medical directors, and other supervisors to address questions like these before they actually encounter the scenario in the field. Ultimately, if a patient with capacity does indeed refuse medical treatment, care, or transport against the advice of the EMS crew, that is the patient's prerogative. Due diligence is still required on the part of the EMS crew, however. That means following your protocols and standard of care for releases. If medical control needs to be contacted, then do so. Keep in mind, however, that simply because a medical doctor orders an EMS crew to transport someone does not mean they have the legal right to, especially if the patient is of age and has legal capacity to consent to or refuse care. Lastly, documentation is absolutely critical in cases like this. If something bad does eventually happen to the patient because he or she refused to receive care or transport as encouraged by the EMS crew, those providers want to ensure there is an adequate paper trail documenting the actions of the crew, what was suggested to the patient, and the patient's clear refusal of care or transport. That documentation should reflect the information shared with the patient to assist him or her in making an informed decision related to the refusal. Remember, if it was not documented, it did not happen. Be sure to document everything related to any care provided. suggestions for care made to the patient, risks of which the patient was informed, the ability of the patient to call 911 again if necessary, and the patient's clear refusal of care or transport. Many agencies use pre-generated forms upon which to have a patient indicate his or her refusal of care or transport. Such a form is in addition to the completion of other routine patient care reports and adequate documentation in the narrative section related to the patient's individual care and refusal. One last point to make about consent is that it can be flexible, in that a patient may consent to certain care or interventions while refusing others. Maybe the patient is fine with an oral medication, but absolutely refuses to have anyone start an IV on him or her. That is completely acceptable. The patient also has the ability to change his or her mind in either direction. Maybe they consented to an IV, it was unsuccessful, and now the patient refuses to allow another attempt. Maybe the patient initially refused an IV, but during transport had a change of heart and wants one. Consent can be a fluid thing. In most instances in patient contacts, consent is never really an issue, and consent is routinely expressed or implied by the circumstances and the patient's absence of objection to the EMS provider's assessment and care. When a consent issue does arise, however, it is important for the EMS provider to have clear protocols in place to follow while also fully, appropriately, and adequately documenting the encounter. Ultimately, consent can be a complicated and multifaceted issue that is impacted by unique patient presentations and circumstances. If more information is required, EMS students and providers are encouraged to contact appropriate personnel within their EMS agency for additional guidance and training. Given your completion of this particular presentation, you should now be able to define consent to care, define types of consent, and describe the refusal of care or transport within an emergency medical context. This presentation was prepared by Waukesha County Technical College in Pewaukee, Wisconsin, and is distributed with an Attribution Non-Commercial Share-alike 4.0 International Creative Commons license. Copyright 2019 Waukesha County Technical College. For information on WCTC's numerous fire and EMS educational offerings, please visit us online at wctc.edu.